Thank you, Mr. President. We're here today when we did not expect to be, recalled to Parliament to consider urgent legislation, the Terrorism and Other Legislation Bill, a response by the Minns government to the terrorism which struck on Bondi Beach a little over a week ago, on the first night of Hanukkah. The murder of 15 innocents and the wounding of many more was both terrifying and terrorising, and shone a light on how fractured we have become as a society when one Australian is prepared to turn a gun on another Australian, when a peaceful religious celebration at a beach is turned into target practice. We are all still grieving, all still grappling with why and how this tragedy could occur, still looking for answers to questions which we are only just beginning to ask. But we are here today not just to recognise the pain of those who have lost loved ones and the struggle of those who are still recovering from their wounds, but to do something practical, to consider legislation with which we have been presented urgently, which we have been promised in multiple press conferences will address the hate speech which has been too prevalent in our society over the past 2 years. Legislation that will help us to heal and feel like a safe, united and cohesive community once again. At a press conference on the 20th of December, Premier Chris Minns is reported as saying, quote, "There is no place in New South Wales for slogans or symbols that incite hatred, glorify violence or intimidate communities," end quote. And indeed, there is not. He went on to say that his new legislation, this bill we are now considering, would, quote, "send a clear message that hateful conduct will not be tolerated," end quote. He detailed that the chant "Globalise the Intifada" would be banned because the Premier said, quote, "it encourages violence in our community," end quote. And of course, he is absolutely correct. The investigation into the cause of this terrorist mass murder is far from complete. But we do know that the cause of these murders was not the guns that were used, but the hatred of the people who fired them, who saw violence as acceptable. If they had no access to legal guns, then they would have just as easily used illegal guns to murder, just as we see criminal groups do all too frequently in our communities. If they had no guns, then these terrorists could have murdered with the pipe bombs that they had in their car. If not these bombs, then they could have murdered using their motor vehicles, knives or other methods, all of which we have sadly seen. We need not just to focus on the means of terror, but also the reason, if anything about terror can be said to be ordered by reason. And so the Premier was right to call out the hateful conduct in our community and to say that this would not be tolerated. This is a precursor to terror, and we have seen its fruits in the sands of Bondi. We know that we have in our community factories of hate, online and in vivo, which teach people that they must hate and hurt other people in our community. We agree with the Premier that there is no place for anything which encourages violence in our community. We support his calls to prohibit hateful slogans. So we were eager to return to Parliament to cooperate in passing legislation which we expected, hoped, would address the root causes of the violence and the terror we have seen, which would live up to the promise of the press conferences. But this legislation is sadly deficient. It does nothing to prohibit slogans of hate. It does not address the hate factories within our city, our state and online. It does nothing to disrupt the repetitive protests which the Premier acknowledges have become a destructive social force. At a press conference on the 19th of December, in answer to a question about our proposed protest laws, Premier Minns said, quote, "I think it's good that ideas are being proposed about keeping the community safe. My view about these protests has been that it is unleashing forces in our community that are not being contained. When you see people marching and showing violent, bloody images of death and destruction, it's unleashing something in our community that the organisers of the protest can't contain. And the truth of the matter is, we can't risk another mass demonstration on that scale in New South Wales. The implications can be seen, in my view, on Sunday. Not just on Sunday, but anti-Jewish, anti-Semitic graffiti and arson attacks through our community over the last 2 years. So we need to take action now." End quote. And the action, the reason for the urgent recall, is this legislation. But this bill does not address the fundamental issues which are challenging our social cohesion, the issues Premier Minns himself acknowledges as destructive and feeding attacks on our Jewish community, a community which was brutalised on the first night of Hanukkah. If this legislation passes, it will not impact at all on a protest which seeks to snake past the Great Synagogue or any other Sydney landmark, accompanied by chants of "From the River to the Sea" or "Globalise the Intifada," even though we have seen what it looks like when the Intifada travels the world to Bondi. And this is deeply disappointing, and why we will be moving amendments, because we want this legislation to work. We want to be part of building a cohesive society in which all are welcome. But to do this, we have to be honest about the causes of the terror. We have to call out the anti-Semitism, we have to call out the hate, and we have to take concrete action, rather than what this bill does, which is tinker at the edges of protest laws and rush some changes to gun laws. As my colleague in the other place, the Honourable Alistair Henskin, so eloquently said, quote, "The legislation that we are now debating is a weak response to the moment that we are in," end quote. We all want a fast response to the terror we have seen, but we need an evidence-based response which will work, not a promise of safety which will remain unfulfilled. We have no answers yet as to how somebody in the firearms registry gave a father whose son was on a terrorist watch list a firearms licence used to buy and take 4 long-armed guns to Bondi. We don't know how our security services did not pick up that these killers had travelled to and possibly trained in a terrorist hotspot in the Philippines for a month prior to these murders. It is surprising then that without knowing all the facts, the Premier is bringing rushed and piecemeal legislation to this Parliament, which will, among other things, give more power to the firearms registry. That same registry which, for reasons we still do not know, apparently granted one of the murderers a gun licence which they had no right under the legislation to have. There is nothing in this bill that deals with the criminal intelligence processes around the grant of firearms licences. This is a major deficiency. The legislation, which is currently the law of this state, already provides that a gun licence is a privilege, not a right, and is only to be granted in the interests of public safety. How was it in the interests of public safety that the gun registry granted the gun licence to these terrorists? This question needs to be seriously addressed, but the legislation this government brings us is to give the gun registry more power rather than to reform its processes. This is difficult to understand and underlines our concerns that this legislation has been rushed to be seen to be doing something rather than doing the hard work of actually doing those things which will create effective and lasting change. The government points to its record of legislating with respect to inciting hatred, including the passage of the Inciting Racial Hatred Act earlier this year, which added Section 93ZAA to the Crimes Act. Anything in this bill needs to build on the foundation of existing legislation and its efficacy. Members would be aware that earlier this year, the Attorney-General charged the Honourable John Sacker, AMKC, with reviewing and reporting on criminal hate speech protections. Specifically, the review was charged with considering the sufficiency of criminal law protections against hatred for vulnerable groups in the New South Wales, including any improvements that could be made, and the interaction between these protections and existing rights and freedoms, including the implied freedom of political communication and freedom of religion, and any other matters related to criminal law reform that the government could consider to enhance social cohesion. The public consultation for this review closed on the 6th of August. The review findings were due to be reported to the Attorney-General by the 5th of November. Has this legislation been informed by this report? a report which is critically important to the matters which we are debating in Parliament today, but a report which has not yet been publicly released and which no one has had an opportunity to consider. Our deliberations would be greatly assisted by the release of this report. The fact that the government's second reading speeches are silent about this report does not encourage confidence that this bill presents an effective and carefully thought through response to the issues raised by incitement to hatred, which we have seen all too graphically in recent days. This bill contains some poor imitations of coalition initiatives. Otherwise, the changes that it makes are all shutting the gate after the horse has bolted. It is not the proactive legislation which we were promised. It is not ordered towards promoting social cohesion and preventing future acts of terrorism. The triggers for much of this legislation are all after the fact. This serves a purpose, but is not the answer that we have all been promised by this government. In fact, the approach of this legislation reminds me very much of Jack's Law, a great initiative to improve public safety by scanning for knives and other weapons. But this government implemented it so that it can only be used after a violent incident has occurred and provided public notice is given of the scanning locations. The bill before us allows protests to be shut down after a terrorist incident has been declared, and face coverings can be removed if there is a reasonable belief that an offence has occurred. This is housekeeping after the problem. Community safety demands that we do what we can to stop the problem. We want to live in a society where we connect through handshakes rather than wave at each other through barred windows. All this year, the Coalition has been promoting laws to prevent the public expression of hate in our community. This legislation does not contain any restrictions on hate speech, despite the public statements by the Premier. And we acknowledge that we should not be unnecessarily fettering free speech. But we also all acknowledge, I trust, that our right to speak freely must be exercised responsibly. No one has the right to call out fire in a crowded theatre because this can cause harm to others. And when there are slogans which can, and appear in fact to have, caused harm to others, if these are still being used irresponsibly, they should be subject to control, as the Premier and the Treasurer have both indicated that they would. This is a government which has been prepared to ban private prayer in certain circumstances, promises to control speech which incites hateful actions, yet, certainly in this legislation, is unable or unwilling to follow through. And they have had time to consider this problem carefully. The public expression of hate in our community didn't suddenly erupt on the first night of Hanukkah. We all heard the vile chants on the steps of the Opera House more than 2 years ago, and which have been continuing ever since. I note in passing that that protest was illegal. It was in breach of the bylaws of the Sydney Opera House for that protest to take place, but nothing was done to stop it, and not a single arrest for those chants has been made since. On the 13th of February this year, my colleague in the other place, the Honourable Alistair Henskins, introduced 2 private members' bills to address the display of terrorist symbols, the very symbols that were found in the back of the car that the two murderers drove to Bondi more than 8 days ago, and also to address issues with public assemblies. In response, the government then brought forward their own legislation dealing with public assemblies outside of places of worship, and we tried to amend that to include our provisions around terrorist symbols and around public assemblies. We also tried to amend the government's amendment, the Racial and Religious Hatred Bill of 2025, to again outlaw terrorist symbols, to close a loophole, and to criminalise symbols that were deceptively similar to terrorist symbols and to Nazi symbols, and to show how significant these issues are by increasing the penalties for their use. Labor blocked these proactive and protective changes. We also attempted to introduce protest law changes by amendments to the Places of Worship Bill. This was blocked in the other place on procedural grounds, and the government continued to block these changes when introduced in this House. And now in this bill, they bring us pale imitations of our amendments, weak laws, which we invite members to help us strengthen by supporting our amendments. Schedule 1 of the bill seeks to amend the Crimes Act by inserting a new section 93ZB, which would prohibit the display of terrorist symbols. We support the intent behind this amendment. We believe, like the Premier, that displaying terrorist symbols is so corrosive of social cohesion and harmony within our community that their display should be prescribed. We can see the influence that these symbols have by considering the flag which was draped across the backseat of the car the murderers drove to Bondi. But like much of this bill, this schedule is rushed and needs amendment. The disruption to social cohesion is so significant that the penalties should be commensurate. This schedule has matters being heard in the local court where the maximum penalty is a term of imprisonment for 2 years or a penalty of $22,000 or both. As a maximum, this is insufficient and does not send a strong enough message about community safety. The schedule also does not close the existing loophole for symbols which are so similar to terrorist symbols that they may be easily mistaken, but on close examination are found to be different. Who has their magnifying glass and their almanac of terrorist symbols out on the Harbour Bridge or at a protest march? On September the 3rd this year, at a budget estimates hearing, I asked Acting Deputy Commissioner Peter McKenna questions about flags and symbols displayed during the Harbour Bridge protest. I showed him photographs of what was widely believed to be an Al-Qaeda flag and asked why no arrests had been made. He replied, quote, "Some of the flags, and we see this all the time, are just slightly changed. When they are changed even slightly, they no longer fulfil the prohibited symbol legislation." I then asked, if a swastika is slightly changed, does that still not convey the same message to those people who are seeing that symbol painted on a wall, for example? And his reply, "I can only tell you what the law says, ma'am. A law that we should be changing, a law we have the opportunity to change today, and a law that remains untouched by the government Schedule 1. I continued the questions by asking, are you saying to us that we need to consider changes to the law so that if something is perceived to be a terrorist symbol, as well as being an actual symbol, it should be prohibited? And his reply, rightly, was, that's a matter for politicians. That is a matter for all of us to take on board and to consider, which is exactly why we will be raising this in our amendments. I continued, are we hearing that that stops police enforcement of what could be terrorist symbols and could be perceived by other people to be terrorist symbols? And Acting Deputy Commissioner Peter McKenna replied, all we can say is that it's either an offence or not an offence under the law. We need to close this loophole, a loophole we are all on notice about. We have the opportunity to do that today. And we need to make it clear that while we are happy to use the Commonwealth Criminal Code definitions of terror organisations, we are not required to wait upon the Commonwealth to add bodies to that list. If we are experiencing terror in this state, we should be able to decide what the symbols of terror actually are, including the flags and symbols of Hizb ut-Tahrir, and not just be limited to identifying flags of terrorist organisations as the Commonwealth Criminal Code suggests, but also symbols of terror used by those bodies, such as the upside-down red triangle of Hamas death squads. And that is why we will seek to amend Schedule 1 so that it will be effective. I intend to discuss this bill thematically rather than chronologically, so it will now address Schedule 4. An issue we have seen since the Opera House protests of October 2023 is the difficulty of identifying any protesters who break our laws. There is no point in having strong hate speech laws if we cannot identify the people who are speaking it within a public assembly. I commend the efforts the police took after the Opera House protest, even using sophisticated sound technology to attempt to identify individual voices uttering those hateful chants. But all these efforts were ultimately unsuccessful. There has been almost no enforcement of our hate speech laws, largely because of problems of identification. And an unenforced law does not speak loudly to our community about the importance of resisting hateful speech. We've been advocating a solution to the issue of identity since February this year. We believe that police should be given the power to stop people joining a public assembly or remove them from the periphery of a public assembly if they are disguising their appearance. and in Schedule 4 we have a pale imitation of our advocacy. We wish to prohibit a person hiding or disguising their identity at a public assembly to allow for proper enforcement of our existing laws. We know that, for their personal safety as much as for any other reason, police increasingly police by video recording. And if a person is seen breaking the law but their identity cannot be detected, then they cannot be prosecuted for that offence. However, what Schedule 4 does is to give a police officer the power to request that a protester removes their face covering and shows their face, but only if they reasonably suspect the person may have or is likely to commit an offence. This is simply impractical. Part of the reason for this amendment is that police now often enforce by video and arrest later. This amendment is unlikely to change this, whereas ours will. It is much better to give the police powers to safely remove a disguised protester, but this bill only gives the police the limited ability to apprehend a person who they reasonably suspect may have or is likely to commit an offence. So in practice, all this does is give the police the right to endanger themselves by going into a mass rally to try and remove someone who's been chanting in a certain way. That's not just completely impractical, it's dangerous, and it will not move the dial on hate speech 1 millimetre. I now turn to Schedules 5 and 6, which deal with protests by creating a new public assembly restriction declaration. This is a good idea as far as it goes. These declarations will operate after a declared terrorism event and prohibit protests in certain places for a limited period of time. But let's be clear about these schedules. We hope that these provisions will never be used, because we hope that the necessary preconditions will never occur again. To operate, they require either a declaration under Part 2 AAA or an authorisation under Section 6 of the Terrorism Police Powers Act of 2022. Happily, this has only happened twice in our history. First, after the Lint Cafe siege 11 years ago, and the second, of course, after the events at Bondi Beach. This is a good thing. We want terror to be rare or non-existent, but it demonstrates the limited reach of these provisions. These schedules provide no answer to the weekly protests and hate-inciting chants that have been occurring in our community for over 2 years. These schedules allow the police to declare the designated areas within 14 days of a terrorist incident having occurred, and it will then make it impossible to get a Form 1 under the Summary Offences Act. But of course, to have a lawful public assembly in New South Wales, a Form 1 is not a prerequisite. So under these provisions, if passed by the Parliament today, it will still be possible for someone to have a public demonstration or protest on the sands of Bondi Beach. We don't think that's appropriate. We don't think that's a good thing for social cohesion. So we intend to amend these laws to make them stronger. We will move to impose a financial penalty on every person who participates in a protest in a designated area after the declaration of a terrorist event. We will also move to make it a serious crime to actually organise such a protest march. These laws are not strong enough to stop socially corrosive protests, but they should at least be strong enough to fulfil their stated intentions. Schedules 2 and 3 contain changes to our firearms laws. We all want a safe society, and reasonable laws around firearms promote public safety. We commit to being part of a parliament that works constructively to provide for public safety, and we are happy to constructively engage with the government in that endeavour. And we have to accept to a limited extent that rushed legislation presented to Parliament within 8 days of a terrorist event in the lead up to Christmas will contain some unintended consequences. And there is no doubt that the changes within this bill will impact on law-abiding farmers, professional shooters, members of shooting clubs and other people. And there will be impacts on people's businesses and their livelihoods. And we need to acknowledge that it is the responsible and law-abiding gun owners who will bear unfairly much of the burden of this legislation. We would have been much more confident in supporting this legislation if the government had engaged and consulted more extensively with gun owners and gun users. We hope the government will be as keen to fix anomalies as they arise as they have been to push through this legislation. We should also acknowledge that we have some of the strongest firearm laws in the world in New South Wales. The overriding principle within the Firearms Act is that a gun licence is a privilege only to be granted on condition that it's in the interests of public safety. There is no right to one gun, let alone 4 or 6 or 10 or whatever number we want to designate. In New South Wales, the Commissioner for Police is responsible for issuing a firearms licence or a permit, which is the only legal basis on which a person can possess or use a firearm. Now, a licence can be issued by the Commissioner subject to conditions, and conditions can later be imposed on a gun licence after it has been issued. The Commissioner is required, without giving reasons, to refuse the issue of a licence on the basis of criminal intelligence or other criminal information. If that suggests that there is a person is a risk to public safety and it's not in the public interest to keep that licence or to issue a licence, it can be revoked after the event without reasons as well. We have these provisions now, and it is important when we pass this legislation not to believe that we have finished the work in this area. We need to understand what the problem was with our existing laws, what the problem was with the relationship between criminal intelligence and the gun registry, what the problem was that meant that we had somebody related to somebody on a terrorist watch list and nothing was done about that gun licence. We need to understand how we focus on irresponsible users of guns without unduly penalising responsible users of guns. And I note that unlike the statements in the press from the Premier, licences are not perpetual. They are for a 5-year maximum period, and there is already provision within the regulations for a period of less than 5 years. I want to draw attention to a couple of provisions within the Schedules 2 and 3, and in the interest of time, do not intend to go through everything in those schedules. I note, frankly, with some confusion, the changes that are being made with respect, I believe it is to 6A, in relation to licences or permits at shooting ranges. It seems that what we want is safer use of guns, and to the extent that this legislation seems to make it harder for people safely and under supervision to acquire the necessary skills to shoot a firearm, this seems like a retrograde step and seems anomalous. I also note that there are a range of new restrictions placed on the number of guns that a person can own. I have not seen the reason why these figures have been chosen, why 4, the number of guns that were apparently in possession of the murdering terrorists at Bondi, is now the safe maximum for gun ownership in New South Wales. But I do know that there are a number of law-abiding gun owners who, on the passage of this bill, will no longer be within the law. I also note that there has been vague announcements about a buyback program, which may be federal. If we're passing the law, is it going to be state? I understand there has been no submission made to the ERC in relation to funding a buyback program in New South Wales. I also am unaware of the provisions that have been made for where any guns are to be handed in. These very practical matters, which do not exercise the mind of terrorists, but do exercise the minds of lawful gun owners, are causing anxiety and confusion in the community, and I urge the government to address these matters as a matter of urgency. I also turn to the matter of the changes to the review mechanism. Currently, decisions were reviewable under NCAT, but that now appears to be changed to an internal review. What was it, 3 months ago? I think I stood in this exact same place when we were debating the Justice Legislation Miscellaneous Bill number 2 of 2025, a page turner I know that we all remember very well. And one of the provisions in that was pressed firmly by the government was the need to ensure that everybody, including minors, had access to a review of decisions about firearms licences by NCAT. And now 3 months later, that very urgent, that great need for procedural fairness has somehow evaporated. It is unclear why these changes are being made. We stand ready to work for community safety. We stand ready to promote social cohesion. We stand ready to work cooperatively with the government. But we want to work...
Can I just say to Ms Higginson, I'm not going to tolerate those sort of interjections throughout this debate. Mr. President. No, I don't. Have you finished, Ms Carter?
One sentence.
Of course.
Yeah.
Honourable Susan Carter.
But we want to work on a bill which will actually be for the benefit of the people of New South Wales and will promote lasting and real social unity.
Mr. President.
Thank you.